Okay, we are reconvened at 3:20. There were three other issues under this whole project work plan. One is a very small one. I didn't think we needed to discuss this with the consultants. Are we clear on the titles? We talk about Eileen, for example, as being Director of Administration. We talk about Elaine as being Director of Communications and Outreach. And they're going to report to, or most of these people are going to report to the Executive Director. Mm-hmm. And we're looked to be hiring a Deputy Director for the IEB, you know.
That's the language. I think we're allowed to call that
Well, we
person
can't-
whatever we like.
Yeah, well, so that's what I was, I'm sure we can call them whatever we
I
want, but
think we can.
should they all be Deputy Directors, or should they all be Directors?
I think they should all be directors, and there may be larger bureaus that a deputy might be needed underneath,
Right,
a larger
okay,
pieces of the organization. For example, the director of the IEB may have two deputy directors.
Right.
In fact, that's really the way the table of organization is laid out. So it would be my recommendation that we have an executive director within director levels for each
Okay.
of the units underneath, bureaus, units, whatever we want to call them. And then, if needed, a deputy director would go underneath the
Right.
director.
okay.
You know, the statute clearly lays out the IEB as a deputy director, and that always caused me a little confusion. Are they the deputy director of the commission and head of the IEB, or are they a deputy director of the IEB, and somebody could come in over them? But
It
you know, the
doesn't
point of
say-
making the directors of the division heads, but I think at some point leaving us some flexibility to consider somebody maybe serving in a joint role as director of a division and deputy director of the overall commission under the executive director. Kind of keeping
Deputy
that,
executive director.
yeah, that's it.
That would be fine, if we saw the need.
Just kind of keeping that flexibility open
If we
to
saw the
us.
need to do that, which would make more sense. I think you're saying that the director of IEB, correct?
Yes.
Okay.
Right, okay, that makes sense. And for a while, I was having a hard time with directors reporting to executive directors. It's kind of a funny relationship, but I'm fine with that. So just as long as we're, okay,
Chain of command.
yeah. Okay, boss. I know you know chain of command, babe.
That's when she makes the
Okay,
salute in the
Colonel,
office.
you got it. Okay, quick update on the status. We have decided to amend our contract with the team of consultants. To remember, everybody, when we put out the RFP for gaming consultants to help set up the organization, we had two RFPs. One was for the law firm, one was for gaming consultants. There really were only two credible bidders. We picked them both and combined them because we felt that between the two of them, we made a really good team. I think we've decided that that was a very good decision. We have decided to amend their contract with an extension to deal with essentially RFA 2, to take what was the first phase. What the first phase was supposed to be a strategic plan, and then we morphed that into a strategic plan and RFA 1 because we came up with the bifurcated process. And what now is left really is all of the work to do all the regs and the rest of the specifications and so forth for the RFA 2. So we've made that decision to go ahead. That's been in negotiation. Do you want to just give us a status report on where that's at, and if there's been any issues or anything that anybody else needs to know about?
No, yes, I certainly can give a little update. We've taken a stab at articulating in the form of scope of work, we called it, that we had, in drafting just the tasks and deliverables that will by necessity have to be undertaken for phase 2, which is our intent in extending this contract. There are some portions that are really ongoing and some that may be undetermined in terms of whether a task can be budgeted for many hours or few hours or really have to be ad hoc. What our consultants are currently proposing, and we've been drafting with the great help of Director Glovsky, is a monthly fee, much like what we have been operating under. And some of the nuances around that have to do with the amount of times that we would want them here and some of the travel costs, and that is still being addressed. What I have asked them to do, and they don't feel needs to be incorporated as part of the scope of work, but can easily be incorporated as part of a work plan, is to delineate those activities with and put them in some kind of chart, much like we have done with our outside counsel, and reflect or identify really the number and individuals from our set of consultants that would be involved in those tasks, as well as the commissioner or commission staff who would be also involved in those tasks, and identify whether there's a timing element or that's an ongoing activity. So we're in the process of doing that. I believe that that's very important, if nothing else, to allow all of us to understand what is taking place, perhaps without our heavy involvement. But I think that's critical, and that's ongoing. Is that a fair summary? It's not finalized yet.
Right.
And maybe let me just say one more. We have run out of, or we will be running out of, as of September 30th, of our current time frame, if you will. And it's incumbent upon us and timely to try to extend for a seamless transition, if you will.
Right.
To try to extend it.
Yeah, and I'll just, say that I think I've been a consultant and I've hired a lot of consultants, and I think having these folks on this kind of a flat fee deal, most consultants are checking every 15 minutes, bill for a quarter of an hour, phone call, 7 minutes, and nickel dime you to death, and the numbers grow like crazy. And I think, these guys have been, and it's mostly guys, except for Kathy O'Toole, have been very, very responsive. We've come up with stuff that was not even contemplated in our original deal, and they've never squawked a bit. So I think it's a structure. You can debate it. Sometimes it's good, sometimes it's bad, but I think in this situation, it's been a really good deal for us, and we've really gotten our money's worth.
Well, the whole regulation writing was not part of the deal.
Yeah, right.
I mean, that
whole
whole
RFA1.
phase one regulation part.
Right, it was not part of the deal, and that didn't cost us one red
Didn't
cent.
cost us a nickel.
Right, so,
And that's a major component, I believe, in the rationale for us to extend the contract, because a lot of the work that has to be done very soon is very much under the auspices of standing up the commission. In addition to the fact that we have not yet incorporated as many staff as I, for one, would have liked, for a whole host of other reasons, posting and background checks and et cetera, et cetera. So
yeah, well,
the thought process is that because it may not be, we may not come back to a meeting next week or the week after, whether to ask for authority for one of us to conduct and finalize those negotiations for the extension of that contract, of those contracts.
yeah, I think we should do that.
I would move that Commissioner Zuniga be authorized to do that.
Second.
Right. Now, so does that mean so you can go ahead, complete the final negotiations and agree with them, and then we would adopt it at our next meeting? Or
Yes.
Yeah.
Yes.
We could easily do that,
Ratify
yeah.
it. at the-
Ratify it at our next
Ratify.
meeting? Right, okay. Any other discussion on that? All in favor?
Aye.
Aye,
Great, okay.
thank you.
Now, the last piece that flows out of the strategic planning, document, is the incredible pressure to get lined up to do the investigations. And we know that we are trying to move like lightning to get the now director of the Investigations and Enforcement Bureau in. We have always agreed that we will outsource the very large portion, virtually all, of the background investigations for this phase one, because there's no way we could possibly staff up to do it. And then even if we did, then we'd have to lay everybody off because we wouldn't need them anymore, so it makes no sense. And the issue that we're wrestling with is how to procure the services of a body to do this work. A couple of background points. First of all, like all of our money, there's no tax money involved in this thing. And in this case, the background checks are paid for by each of the bidders. The bidders give us a check for $400,000, and that $400,000 goes to doing the background checks. And if we need more money, then you go back to the bidder to get more money. We are in a tremendous time push. You know, we really want to move this as quickly as possible, but we have also resisted moving too fast for the sake of absolutely protecting the integrity and rigor of the process. And we have been working now with the people, the two companies, not just one company, but two companies who are almost unique, very close to unique, maybe unique in the business in terms of people who know the gaming business really well and who do this background check business and have done it repeatedly for all of these companies across the country and across the world. So the question that we need to resolve is whether we will do a competitive procurement, running the risk of losing significant time and probably doing competitive procurement merely to pick the people that we've already got, or do either a sole source agreement or a contract amendment with these people. So it's something of which I've gone back and forth on, and we've even gone back and forth about the extent to which to discuss it. But we do need to resolve, and we have to resolve it today because we're under such pressure to get going. And I just throw it out there, and I think we all just need to talk about it and make a decision and do one or the other.
I want to bring up a couple of points to complement what you're saying, Mr. Chairman, and that is that in addition to the schedule or the time frame, there is a complicating factor relative to the scope of, that I see, in my opinion, the scope of licensing process that takes, that comes to fruition soon. And there's an overlap, maybe that's the wrong word, but there's a close nexus to the investigations, between the scope of licensing and the investigation.
Very much, absolutely.
And
And the scope of licensing will be starting October 13th, probably.
correct, correct. And I see that's a key feature that you're alluding to in terms of timeline that, at least from my perspective, I came to appreciate until recently, when I dovetailed when I really dove into the strategic plan that was recently delivered. And because of that iterative nature, it occurred in the questions that will surface that we cannot reasonably anticipate at this point. And because we anticipate, however, that our consultants will be online to help us during the scope of licensing, there's an element of a rationale to consider just what we are, or the question that you posed for all of us, which is whether to conduct a procurement that might end up leaving us in the same place that we may be now.
Thanks, Brandon. Yeah, I mean, go ahead.
I also I also wanted to chat or to talk a little bit about procurement, the procurement regulations that we adopted, perhaps by way of background and as a refresher. 801 CMR, that regulations for state agencies that we adopted back in April. I see them as having or fulfilling three important goals that I would like to speak a little bit about that are not exclusive to those regulations. If we were to exempt ourselves from those regulations for this particular procurement. And those goals that I would like to highlight are that in general, those regulations like that are usually set forth so that there is a clear confidence that tax dollars are being spent wisely and generating competition. A second piece of that often is that tax dollars are usually, or public dollars are usually providing opportunities for small or disadvantaged businesses. And a third one is really to utilize best practices when procuring a process like this that also generates public confidence. I believe that a lot of what we have done here in parallel to the procurement regulations would help us, actually would suffice with those goals depending on how we think about them. And I can speak to that unless you think I'm going in the wrong direction here or
Well, I think it's, I mean, it's an important, it's an important issue, and we wouldn't be wrestling with this if the fact, in one sense, it's totally obvious that the team that we've got are the best people in the industry. They were competitively procured. They're great at this. They're working seamlessly. We all want to go as quickly as possible. It seems like a no-brainer. But on the other hand, this could be, some number of millions of dollars. It's a lot of money. And that says, we need to be attentive. So I think your idea of figuring out, the other point that's important is we were exempted from the state's procurement laws. We voluntarily chose, for the most part, to go use the state's procurement laws, and I think that was a good idea. But in a situation like this, where time is so much of the essence, maybe we should not voluntarily go through a process, which is probably a pointless process anyway. But I think your idea of laying out, what the public policy issues are and how it would get addressed is perfectly reasonable.
Right. Well, that was going to be one of them, that we were exempted from the public procurements for many
reason, yeah.
for many good reasons, not the least of which is that we can only make decisions like this or deliberate about decisions like this in the open public meeting, which effectively complies with a major policy, and that is to be being open about it. I also believe that there are ways of generating competition that we could contemplate that are outside of the procurement regulations. One thing that I wanted to mention, which stems from how we went about when we engage with these consultants, is the fact that we may be well served to have more than one company conducting investigations for several reasons, not the least of one of which would be if there are perceived conflicts, given the history that many companies have elsewhere prior to us. Having more than one company would be a way to address it.
Well, this one is two companies.
Right.
A present consultants is two companies, right?
Right. Also, in the venue of complying with a tight time frame, we could undertake, I'm just throwing this as an idea, undertake the steps that are normally reserved for a small procurement, effectively soliciting quotes from qualified firms or soliciting directly for a number of firms and pre-qualifying them to conduct some of these investigations. This would become a matter of decision for us as a way to balance the objectives of sound procurement regulations and matching the timeline that we have in front of us.
Right.
Mr. Chairman and colleagues, I approach this from a little bit different standpoint, but come to the same conclusion. It seems to me from a cost standpoint that bringing in somebody who's entirely new to the process is going to have its own costs. It's going to have a cost in terms of time. It's going to have a cost in terms of knowledge transfer from the kind of background and environmental intangibles, let's put it, that these consultants have achieved. And in terms of simply the cost of any bid we're likely to get because of the ramp-up time and knowledge transfer that's going to go into a new contractor being effective. So while that may not be the major part of the cost of a new contract, it will not be an insignificant part of the cost of a new contract. Secondly, there's the pure time factor. It's going to take time for somebody to get up to speed and move forward. The transition in this kind of a thing is never seamless. Thirdly, we've all had a chance to observe these consultants, to get to know them and to get to know their operating characteristics and their operating ethics. They've not told us what we want to hear. They've given us good, sound advice. They are people who have a vast experience in this space, and they are people who I think are of the highest integrity based on observations and contact with them. And I think that's the kind of person we need on our team to take this next step. And finally, they have, at least the Spectrum side of the duo, has just recently conducted the investigations in Ohio, and therefore is in a position, perhaps uniquely, to take advantage of fresh information that may overlap and affect some of the people who are applicants here, either as on the face of it or as financiers behind the scenes. So it seems to me that the public interest is well served by continuing with these consultants, both in terms of the cost and in terms of the timeliness and in terms of the services and in terms of the quality of the services we're likely to obtain as a result of their continued participation in this undertaking.
If I could speak to this matter, with regard to the investigations themselves, background investigations are something that most law enforcement agencies are capable of conducting, as we will be capable. But gaming background investigations are unique. They are much more intricate. It takes an awful lot of experience and contacts to conduct them thoroughly. Financial folks, there is no one here in this state that is capable of conducting these background investigations from a law enforcement perspective. I know that the consultants that we are using, their team of background investigators are contract employees who are former law enforcement professionals, former gaming professionals who have conducted these particular investigations in many jurisdictions over a number of years. So I'm very confident in the staff that they could provide to us and the quality and the ethics of those individuals. I agree that the timing is an issue, and possibly, one of the how I look at this is that we've hired our consultants to help us enact the law and help us stand up the commission, and frankly, this phase 1 investigation is part of that process. I think another thing that we could do is put a procurement out for the phase 2 evaluation. That's a very different process, which is, evaluating environmental concerns, construction concerns, a number of concerns that we could, at the same time that we're conducting these investigations, be looking for help, which may be a very different group for that evaluation process. So I'm agreeing that using our current consultants would be a way to be efficient, effective. We already have the working relationship, and we are trying to carry this momentum forward, stay on track with the process, and this is a way to do that. And we're talking about it publicly, so this is something that is important to all of us.
Well, to that point, one of the important points to make or actually reiterate is that whether we extend the contract or conduct a procurement that is slightly different from what the regulations provide for, if you will, a big important thing to do is articulate the reasons why, which frankly you have eloquently done. You both have done.
Both have, yeah.
As to why the business case, if you will, for continuing or exempting ourselves from the regulations in this case.
Commissioner, anything to add? What's
No,
your?
I follow the recommendation, Mike. I think one of the reasons that we married the two gaming consultants was, I think we found in one arm of the body, I guess, but we did see a significant amount of work in these background investigations. I mean, Bernie is a member of their team, I believe, is a former FBI guy. So, we certainly valued their level of expertise in this area when we decided to marry the two together. So it would make sense, again, knowing that this is probably a pretty limited field. I'm not completely familiar with the other players who might be out there, but or who our consultants may decide to bring into the picture as kind of contract help as part of this process. But as you lay out the recommendation for us to kind of keep those questions in mind, who these other players are. Like Commissioner Cameron says, it's not a big field of people that we're talking about.
Yeah, I think that the other types of people who could conceivably say they could do this would be the Deloitte Touche type people. There are some big security firms like Kroll that do different kinds of security things. So there may be other people who would be possibly even as good. It's inconceivable to me that there's anybody who would be better, and that's the issue. I think we're in a situation where there's a little bit of competing public interests, and it does seem to me that what we've heard from people is we do hear what you're saying about integrity, and we don't want you to compromise on integrity, but we do want you to hurry, and all of our constituents want us to move as quickly as we possibly can, and the conventional procurement process is long and subject to complaints and challenges. And given all of the circumstances together here, the combination of the funding source with the time pressure, with the known quantity of these people, by the way, they have a project manager who's the former highly regarded police commissioner of Boston. That's our project manager. When you put all that together, even though it's a significant amount of money, probably, I think I come down on the side too that it would make the most sense to do whatever the proper, exempt ourselves as we were exempted by the law from the procurement regs, and do either a sole source procurement or an amendment, whichever is the most appropriate way to go. Just because it's a significant amount of money, it's something that I really feel it's important for us to talk about and have on the table and weigh heavily. But I think when you weigh the public interests, I think I come down where Commissioner McHugh started, and the others have agreed that it's probably the right way to go. Are we fairly unanimous?
There seem to be a consensus that we, for the purposes of procuring investigation services, the services of investigative companies, that we exempt ourselves from the regulations that we adopted back in April for the purposes of this one procurement.
Right. And I think probably,
I would, when we get to it, I would move formally that we do that.
Yeah. And I think, and this is really a question as much as anything else, there are, under any set of rules, traditional or otherwise, circumstances where sole source procurements are justified
Yes.
because of a series of circumstances. We do have a series of circumstances here, which, as you say, probably would qualify for a sole source procurement, even if we weren't exempt from all the rules anyway. And maybe that's the best way, maybe to write up the case
Right.
that we've just been talking about is the best way to do it, rather than to amend the existing contract.
Okay.
That's just my instinct. I don't know if that's,
The other piece of this that I think is worth mentioning is the fact that our team of consultants has proposed to assist us in training our own people. It is our intention to have trained staff, state police, and other investigative staff who will be very capable of conducting these investigations. So it will be an issue of phasing out. But the training piece, I think, is critical to us moving forward, to the ability to have our own folks out there learning this industry and the ability to conduct these investigations. So that piece, I was very, very impressed with that piece of the proposal also.
There is, just to your prior point, Mr. Chairman, there are provisions for sole source and procurement, and the biggest or the main requirement is that the reasons or the business case for that sole
Right.
source is clearly documented.
right.
And we, to a large degree, we have done.
I mean, it's,
some of
yeah,
that today.
it's as compelling a case as there is. It's just that notwithstanding that, I still think it's
Yes.
something we need to think about carefully. But I think we have, so I think then if there's a consensus here, great, then, so what, somebody want to put it in the form of a motion? How about Commissioner McHugh? You did a great job on that first one.
So should I make a shorter motion? Or do you want-
I know that's asking a lot,
do you
but
want- I don't know. So I would move that that the commission exempt itself from the procurement regulations found in 801 CMR that we adopted earlier this year for the sole purpose of engaging the firm of Spectrum and the firm of Michael and Carol to assist us with the investigation of Phase 1 applicants, provided that suitable terms, arrangements, and conditions of the contract can be arranged.
I second that motion.
Thank you.
any more discussion? All in favor?
Aye.
All opposed? Okay, good, that was a big one.
Thank you.
All right, item 4A. How is it? On the personnel searches, I think they're all, we're moving ahead. There are a couple that may well be concluded within the next few days. We aren't going to have a formal meeting next week because some of us will be away. Can we set up a structure so that the hires can get made? We don't want to wait 2 weeks. I think we probably will get the background checks completed on 1 or 2 people this week, probably. And we don't want to wait another week or 2 before we hire them. Can we just delegate to the hiring manager to go ahead and make the hires?
But
Or
we
at least
can,
subject to ratification?
provided that we specify, I think it'd be helpful to specify which
ones?
hiring manager we're going to delegate which hiring to. And
Yes.
Well, I guess it would, I mean, I've been the hiring manager on the ombudsman.
Right.
And that's one we hope will be done quickly. Commissioner Cameron's been the hiring
Right.
manager for the Racing Commission Division Director.
And for a paralegal? Is that
And the
likely to
Paralegal is
come?
another
Yeah,
position.
and the
that
staff
yes.
attorney we may have done too, and you've been the hiring manager for that, right?
Yes.
And it would be,
And Commissioner McHugh is also the hiring manager for general counsel.
But that won't be
That
done.
won't
That won't be
That
done,
won't be done.
and the staff attorney may or may not be, but certainly
No,
two
Staff attorney could be, yeah.
background checks, two by,
Oh, background
Yeah,
checks, oh,
yeah.
that's right.
But anyway, so can we just do it? Can we just say that it's all right, that if the hiring managers come to the conclusion that we can go ahead and start the process going with the person we've selected, to trusting in the hiring managers that we've made the right choice?
And the wisdom of the hiring manager, yes.
Right, and then ratify that at whatever
Right.
the next meeting is?
Right.
Okay. And so do we need to do anything formal for that, or can we just go ahead?
No, I think if we're going to, the plan is to ratify it, and I think we go ahead and do it.
Okay. Okay, great. Well, then all hiring managers will just jump to it as soon as, from wherever we are, as soon as we get background checks successfully concluded, we hope. Okay. From the Director of Administration, Ms. Glovsky. That whole last session was really yours, so I don't know how much more you've got.
Well, and I guess that highlights a lot of what I've been doing over the last few weeks has been coordinating meetings among the commissioners with the consultants, scheduling meetings, making sure that different parts of the strategic plan have been addressed, questions have been addressed. So that's taken up a significant amount of information. Along with
Could I just say before you start that the way the meetings over the meetings with individual or small groups of commissioners and the consultants took place over the last couple of days, I thought was really very helpful. And as one of the Commissioner Zuniga said, I think the notice that so-and-so is going to be meeting with the consultants, or so-and-so is going to be meeting with, so sort of a plan of the day that's published and everybody can see it is really a very helpful thing. And so this has all been coordinated really well and is helping us really to move forward in the right direction and the right pace.
Thank you very much. And as part of that, as you know, that with Kristen Gooch representing sort of the project management on the other side with the consultants, we've been working on a protocol for communication with the commission over the next phase 2 work that's going to be done. I think we've come up with a template that works for the regulations, but also potentially works for other situations that come up. The goal would be certainly to keep the commission involved in understanding all the meetings that are going on with consultants, whether they be in person or by phone, without the cumbersome nature of being copied on every single email. There's a lot of communication that can go on back and forth. It's not necessary for you to look at every single item, but I'll be working hard with Kristen Gooch to make sure that the important information that you all need to see is placed in front of you as soon as possible. We're also, as noted earlier, going to be working on figuring out how we sort of chunk up the regulations so that the policies that need to be addressed first are the ones that come to you first. I've been working very hard with Commissioner Zuniga, as noted on the statement of work, that I hope that we will be able to wrap up by the end of this week for the extension of the contract with the consultants. Commissioner Stebbins and I have started to work on the ISA, which is an agreement between 2 agencies with the Donahue Institute to do some research regarding host communities and surrounding communities.
Collins Institute.
Collins Institute, I'm sorry. Thank you.
I didn't say a word.
It's in my brain, I apologize. With the Collins Institute about doing research for the host communities and surrounding communities, and we're going to be taking a hard look at that over the next week or so and get that solidified with them. Working on a couple of procurements. We have an RFI for research that has questions that are due this Friday and that will be posted within a week or so afterwards. We also have a procurement for financial advisory services that has questions due shortly as well. We'll be responding to that. So we're working through those. Preparing for new hires with the facilities, trying to get phones, computers in place so that when we are able to hire people, we're ready to get them to work, because we all know that there's plenty of work for them to do. And then the last item is, I believe I sent out to all of you probably a week or so ago a job description for a generalist, which is, and I would like to put a posting up for that. Really a senior generalist and a junior.
Senior generalist.
Right,
and a
I'll
junior
come up with better
generalist.
titles for it, but really, I don't need a staff accountant or an IT person right now. There isn't enough.
Senator Chajuga, wouldn't you be a senior generalist?
I don't have enough work for a particular job description. I think, as we all know, since we've all been rolling up our sleeves and doing everything, what I really need is a couple people who can jump in and do all the things that need to be done, and in particular, somebody with experience using Commonwealth accounting and HR systems as well. But that's
Great.
all
It's
I
going to be a
have.
very different, in 60 days,
Yes.
if we can just get through the next 60 days, it's going to be a very different place with a whole bunch of new people. So hang tight.
Great. Thank
Anything
you
else
all.
for questions?
No,
Great.
Thank you.
thanks very much.
Thanks, Ellie. Also on this item, we've been talking about adopting a set of core values for the organization. A draft has been distributed, and I think it's in the packets. If you've had a chance to review them, we can talk about them, or amend them, or ditch them, or adopt them. I mean, I'll just say, I think the participatory, transparent, and fair process is something that we've talked about from the very get-go, and I think that's almost a brand that every one of us needs to live and breathe, so that's pretty clear. And in talking about an environment where it's non-bureaucratic and where people can talk at a relatively flat level of hierarchy, and people are encouraged to speak their minds, but on the other hand, when decisions are made, we're all in them together, and we're all implementing them. The overall commitment to the integrity of the regulatory process and to our use of code of ethics, I think, is straightforward, but I think it's a useful addition to say, to be mindful of the balance between rigorous regulation and the burden of compliance. Our operators will be our constituents too, and it's important that we be mindful of finding that balance. The diverse workforce and the diverse supplier base, and as we've talked about, we had at our education forum, diversity alone isn't enough. People need to understand what an inclusive culture is about, and that's clearly something that's a core value for us. And then finally, I think highlighting customer service. We want our communities, we want our citizens, we want the developers, we want people to have great experiences with our personnel. If you walk in our door, if you call up, if you write a question, you get an answer, all that kind of stuff. So to me, those are really central values that I think it's incumbent upon us to try to adhere to and to convey to this burgeoning staff that's going to start lifting off in the next couple of months. Anybody else?
I appreciate the thoughts that went into this. As I mentioned in a previous workplace, we took these types of culture and core values and made sure every employee got a copy, even to the extent of making it nice enough that somebody would frame and have within their cubicle or their desk or their office, because obviously they're guiding principles that we need to reflect on every day and continue to conduct ourselves with.
I would just like to echo what's being said. I have a great place for these core values to copy them too, which
In the
is the
personnel
employee
manual,
manual at the
absolutely.
very beginning,
Right.
even though I will also give a brief update on that in a minute,
Right, good.
at the very beginning.
So we adopt them? I think it's worth formal
Yes,
adoption.
I think so too, very well done.
I move to adopt our proposed set of core values for both the commission and all future employees and current employees of the Massachusetts Gaming Commission.
Second? All in favor?
Aye.
Unanimous vote. Thank you.
I think Commissioners, the point of Commissioner Stebbin is that we find a way to, and Commissioners, that we find a way to publicize them,
Right.
and so we've adopted them now. They need to be part of the wallpaper, and,
Right. Well,
and as well as our day-to-day thoughts.
right. Yeah, I agree, we'll do that. We'll talk about different ways to promote them. And then the last thing under this item is just next week, there will be a meeting at the same time. I think we're back at Washington Street, but it will not be a formal meeting. As it turns out, a peculiarity of the law doesn't let us have a quorum that doesn't have a majority in the physically present, which is kind of silly, and we might recommend that get changed. But we can't have a meeting even though we could be a part of it. But we are going to there will be two commissioners here, Commissioner Stebbins and Commissioner McHugh. And I think we are talking about having representatives of the labor movement, labor organizations, and some folks who have some ideas about community mitigation that have been wanting to speak to us come in. I don't know if there are other things that you all want to have on the agenda.
We're actually meeting tomorrow with our chief of staff to think
Set
about
that
some
up.
topics and
Okay.
make an informative
Okay.
session, as well as our plot to take over the commission while the three of you are out of town.
I'm taking this with me.
No impersonation.
I didn't realize that was on the agenda. That's good.
Okay. Item 5, finance budget. Commissioner Zuniga, an update on a couple of
Thank you.
things.
Just a brief update on, I have distributed a draft, I would characterize as a draft memorandum based on, or for a procedure for reimbursing host communities. These dovetails, and Commissioner McHugh mentioned that there is clear language on our regulations as currently drafted relative to the monies that will be reimbursed, and the statute sets forth for those host communities. My intention here was to establish a simple and clear procedure for how and when those communities will be reimbursed. And these procedures really assume what is clearly in the regulations, which is that a developer or operator and a host community or surrounding community would come to an agreement and draft and send us a letter of agreement, I believe is the exact words, to this commission for us to jumpstart that process, the process for reimbursing. The previous comment that you have made, Commissioner McHugh, if there is no agreement, well, we don't deal with that eventuality here, because that will be dealt by virtue of regulation, or however we want to deal with it. I submitted it as part of the packet. If I can take any questions or
I had questions until I heard Commissioner McHugh explain why in the regs, because I wasn't sure I agreed with this, but I think I do now, so that makes sense to me.
I no doubt am misreading this document, but it seemed to me that under the phase, you had two alternatives, the front-end payment, the before the expenses were incurred payment, and the reimbursement section. And in the before they were incurred, it looked to me like no matter how far the community went, it could only get 50% of its costs reimbursed.
Until they submitted a request for reimbursement. We should talk about this. Alternative one that I am suggesting effectively fronts 50% of whatever they agree to. Allows them to start spending, submit a request for reimbursement, if you will. At that time, we would deduct 50% because they have been reimbursed for upfront, and reimburse the remaining money. It's a mechanism that attempts to have some kind of progress payment nature. Does that clarify, Commissioner?
I'll read it again with that thought in mind. I didn't realize the second piece was designed to coexist with the first piece. But that's designed to make sure that the money's spent wisely or in the agreed-upon fashion? Those two probably will be the same
Well,
in most cases, but
it's designed as a control mechanism to some kind of fiduciary duty that we exercise by fronting money, if you will, or sending money with the evidence that it's going to the right place. The idea of fronting 50% recognizes that communities will not want to be necessarily out of pocket and wait for us to get our reimbursement process in place.
would the same purposes be, I'm just thinking about, a small community that doesn't have a lot of loose change or any loose change
Right.
lying around to pay suppliers of the kinds of things. Would it be sufficient for the cost to be incurred, i.e. they receive a bill from a supplier and send us the bill and we send them the money to pay the bill?
That could be sufficient. I will just stress, by the way, that the way I drafted the procedure, it would be sufficient to send us as proof of payment a warrant or a check number. And at that time, technically, the funds are committed, but not necessarily spent. And I may be splitting hairs here a little bit, but by the time that, let's say, a Board of Selectmen approves a warrant, funds are committed, but not yet dispersed, and there could be that time frame that communities use to send us just that proof of payment. But your point is well taken. If I go a little bit further, if they enter into some kind of contract
Right.
with a consultant and they say, we're committing to this amount,
Right.
not to exceed or fixed fee, even if it's not disbursed, that could we could accept that as proof of payment and send that money at that time.
Yeah, I think that if we could make that slight change, that would be helpful to the communities. I can think of small communities that just don't have that extra cash lying around or available to them. Nobody has it lying around. Available to them to pay for some of these things. That would solve the objective and at the same time not affect them. So I think it's a good process if we could make that
It's
change.
definitely, you've read it more closely than I did, but it's definitely worth, thinking it through. I mean, we want to make this as easy as, and we should exercise some fiduciary role, clearly, but modest and not any kind of onerous process on anybody.
No, this was, there's no prescribed form. There is simply just
Right.
send us a letter with a proof of payment. We could talk about just what that
Or the
would be.
receipt, or the bill is.
Or a commitment.
Right.
If I'm summarizing well.
Right.
And I can make those changes and reflect that. Or, by the way, if they do have a lot of cash flow, just wait until they're done. And that's a second alternative.
Right.
It's up to them.
I have a couple general questions. One under the first scenario, we get down to letter E. At the end, tail end, you talk about the balance of monies that the commission has reserved for the host or surrounding community have been expended in full. So we take the $400,000, we know that a minimum of $50,000 is going to be spent on, again, reimbursing these host communities. And so how are you suggesting that we are going to set an amount that will be available out of that $400,000? I mean, I guess this somewhat goes back to the investigations piece. I'm a little nervous about the size and cost of these investigations. And I know we have tools to be able to go back and solicit additional funds, but you're talking about reserving, some monies aside. I'm just trying to get my arms around your thought process and how we decide what that is.
Let me clarify. Assume that the $50,000 that's reserved per statute has already been spent. But that the negotiations are ongoing, and the operators and the host communities agree by virtue of sending us a letter of authorization, I believe is the right term, yes, that there will be additional expenditures of, just to pick a number, $75,000 extra. If they want to continue the commission to be the conduit for the reimbursement of those monies, they may not want to, but if they do, they could notify us and request reimbursement. As long as we have actually obtained those funds, we will reimburse those funds. That was the intention behind the notion of reserving funds and then making them available.
Okay. And I'm assuming that at this point in the game, a surrounding community will be a community that an operator has approached, recognizing an impact, knowing that there's a phase down the line where we can identify surrounding communities and want to make sure that funds are set aside for those negotiations between that new surrounding community that we've designated in an operator.
Correct. I mean, and what you mentioned, it could work both ways. The operator may have approached, or the surrounding community may have approached the operator to say, we believe we're a surrounding community and we want to sit at the table and we want to come to some letter of agreement as to those negotiations. In that instance, if the operator decides that they're not, the commission has the ability to say eventually that they are. I don't know if I answered your question.
No, you did. My concern is somebody who raises their hand and says, I'm a surrounding community, I want to start getting reimbursed, and they come to us for some reimbursement, but yet have not had a direct interaction with the operator, nor have they necessarily received the surrounding community designation from us at the appropriate point.
Yes.
Well, they wouldn't get any
There
money
wouldn't be-
because they have to have an agreement with the
That's right.
operator.
There would be no letter of authorization.
Got it.
The genesis is the letter of authorization
Okay.
that sets this procedure.
And we want to reiterate, people are forgetting, I think, the ombudsman will fix this, that communities can go straight to the operators and
Right.
get money now. Some have done it, and Springfield's talking about, they're not going to worry about our 50,000. They're going to go straight to the bidders and get monies directly.
Well, that leads me to my last question. I mean, is there information we should be requesting from the host community for our own informational purposes, to see what they've already asked? Not that I'm expecting a community to double dip, but is there any interest on our part in knowing what they've spent money on?
That's a good, you could double bill, that's a good point. Yeah.
We're not encouraging anybody to do that, obviously, but, is that information that's important to us? I don't know the answer to that question.
Well, this dovetails into the notion of the duty that we have, the fiduciary duty, if you will, to make sure that those monies are spent as they are intended. If we are part of that, we have a role. If the operators agreed and the communities agreed that the reimbursement process would be such that they don't have to involve the commission, or they don't want to.
Right, but his
involve
point
the
is
commission.
theoretically you could do both. I mean, if some community wanted to play games, they could. They could get direct monies and not tell us. So I think probably in our RFA 2 process, we will ask to know all of the monies that have been paid to any vendors on behalf of this, or any money that they've been compensated for.
But in that scenario,
I think it's whatever relationship, whatever monies they've asked us for. Again, I'm asking the question for us to consider, is that information that we should just request from the municipality, is not to necessarily drive their reimbursement, but just for our information and generally about this process.
They can't, under the regulations that go into effect now, the developer, the applicant, has to disclose as part of the RFA Phase 1 process, or perhaps later, but they have to disclose all the payments that they've made to the community, whether they're payments that that come in this form through an agreement that we act as the dispersing agent, or that they've done independent. And so that's an obligation of theirs. This, it seems to me, we can really work on a kind of minimum scrutiny, because the only way that money can come out of the $400,000 here is by agreement. Right. And once we get to the contested things, which we will in phase 2, then I think we have a heightened duty of investigation and tracing. But here, it seems to me, we can rely on the self-interest of the developer and the town and the disclosure rules to help us.
It's a very good way to put it.
Yeah. But in the final analysis, Commissioner, I think the answer to your question is yes, we will know all of the disbursements that have been made.
Do we have any standards for what kinds of services are reimbursable?
My read of the regs and the statute in these particular sections are that it's mostly advisory, consulting, lawyers. I may be wrong. There may be others that could go under the mitigation of negotiations. But I always sort of thought of them as soft costs, if you will. Nothing for this particular category. Nothing that would be mitigation monies on the presence of a casino, additional fire trucks or anything
Had a
like that.
question about.
Yeah, not at this juncture.
But I would agree with that, but also that self-regulated because the commission, because under this structure, the bidder has to sign off on it. So presumably they're not going to sign off on buying a new fire truck as part of the negotiations.
Why do you think that's so? That they wouldn't sign off on something that they think would help them move their project along?
Yeah, they might, but I guess if they did, it's their money. I mean, it's okay. I mean, this Springfield, somebody gave a big contribution to the South End Community Center. I don't know. I mean, I'm game to
Well, I guess what I'm saying is if we have some control over the monies, this particular piece of money that, if something came in to be reimbursed that we questioned, do we have a mechanism to question?
do you have the language right there, Commissioner?
I don't think it's
No.
specific.
The statutory
Yeah,
language
what it says up to 50,000 for what?
for
minimum-
negotiation
a
and
minimum of
mitigation
50,000.
in substance or effect. And we can get the exact language here. Again, I think that and I will get the exact language, but I think that the safety valve is the
agreement.
required agreement, and if something comes in that looks like it's off the wall, then we can talk about it here. And the publicity that creates, it seems to me, is a substantial break on a mischief. And the requirement that this all be disclosed in the RFA 1 application process is certainly going to factor into the investigation that occurs as the RFA 1 is explored. I don't know whether that satisfies you, Commissioner, but that strikes me as, at this stage at least, a sufficient break on this, while allowing the cities and towns to get the help that they need.
One way to think about these letters of authorization prior to costs being committed, hopefully, is as somewhat of a budget. And if they were to send and itemize the costs in a detailed way that would elicit questions, that would be one way to, one time rather, to come think about and question if there may be any questions.
The statutory language is of not less than $50,000 of the application fee shall be used to reimburse the host and surrounding municipalities for the cost of determining the impact of a proposed gaming establishment and for negotiating community mitigation impact agreements. So that's pretty narrowly defined, and
It's negotiation, not necessarily.
Cost, assessing cost of mitigation,
Right.
not mitigation,
not
but
doing the
assessing the cost.
mitigation.
Correct.
And then
And I
that,
think we can have the ombudsman talk, we can
Right.
put out an advisory that reinforces that, sort of makes sure people have reasonable
Right.
standards in mind, so that we have, in effect, given them notice if they come in with a fire truck.
right,
Just one final note related to this, and I appreciate the two types of processes for the reimbursement. I think we'd all be in agreement that each project is going to drive different costs. It's going to drive more surrounding communities or fewer surrounding communities to be impacted. So, is it come back to a budgeting question of this $400,000 check that we're getting? Again, I know we can go back to an operator and ask for more if some of our costs start to increase, but I think we just should be mindful of that. One project may dictate more people coming to us for a slice of the 400,000. It's more raising a flag as the scenario kind of rolls itself out. But
I want to just make a comment. Your point is well taken, but the way I understand the monies that would go towards determining and negotiating the impact are as follows. 50,000 would be reserved, of the 400,000 would be reserved for that purpose. Any monies required in addition to that do not come out of the remaining 350. That 350 allows us to conduct the investigations piece that we will conduct. If one of the host communities determines that they really need to do some kind of environmental impact study that's going to be very costly, and the developer agrees, in other words, in excess of 50,000, then that's an additional pool of money. It does not come from the 350,000 that remains from the application fee.
and that, you've referred to that, Commissioner, here in the very last paragraph here, but that paragraph might be made just a little clearer to refer to the specific subsection of the regulation that says that they've got to pay, if they're going to do it through us, and they authorize, the developer authorizes more than the $50,000, then they have to provide the excess money with the letter of authorization to us. So if we simply refer to the reg, which says that, that would clarify that point, so it doesn't come out of the 350.
Isn't that sort of tied up in the issue that we've kicked down the road about the additional monies for the background checks? That the statute isn't very clear.
No, the reg says this. It's still, that issue still remains, but it's not altered by this, because this leaves basically the $50,000 that's cut out of the $400,000 as the only exemption. The $50,000 is going to go to potentially to the city or town. That will leave a residuum of $350,000. If the city or town wants more than the 50,000 and the developer agrees, then the developer puts in more money, but it's dedicated to the city or town, not to the cost of the investigation.
But I think if I were a developer, I would say, look, I'm out 400,000.
Yeah.
And you haven't spent it all yet.
Right.
And so if the cities and towns need more, take it out of the 400. The legislation says no less than 50. And as long as we can get it all back, as long as we write a reg that clarifies this problem. So if I were the developer, I'd think spend the 400 first, then come back to me if you need more money.
But our reg that we just approved doesn't permit them to do that. Our reg just approved says, if you're going to, you developer are going to authorize more than the 50,000, then you've got to put up the additional.
Oh, that's a reg
money.
we adopted today?
That's the reg we adopted
Oh,
today.
how did I miss that?
Well, you haven't.
Right.
it's not official.
Right.
Okay.
Okay.
All right, so
So
what I
that's
said might
problem.
be a good idea, but that's not, it went the other way.
That's
All
right.
Okay.
So that's for the moment. Now, we've got to write another set of regulations to deal with this problem, because frankly, the $50,000 isn't going to cover everything
It's
these
not gonna
people are
go a
going to need,
long way.
right? It's not going to do it. So this is to get the ball rolling until we have standards by which we can judge the reasonableness of expense requests when there is no agreement, and we'll do that. We have to advance that up front, but this is to get the ball rolling
Do
and
we
allow
know-
cities and towns to get some relief while we're working through that.
Do we necessarily need to prioritize who has access to the money first?
Pardon me?
Do we necessarily need to prioritize who has access to the 50,000 that we're making available first?
Not, we don't have to, we don't have to do that now because, again, it's by agreement. We will in the next set of regulations.
Because it's first comes, first served now, right? Whoever goes to the developer and gets an agreement.
First one with an agreement to the developer is, yep, with the developer. It's a first served, yes.
Does that answer your
Yep.
point?
And you may be alluding to surrounding communities. I kind of thought about that. It occurs to me that anybody to get an agreement with a developer first is likely going to be the host community.
Yeah, I mean, the developer is presumably going to
Presumably
set
going
that
to agree to
standard.
that one a lot easier than anyone else.
Right.
But much of the mechanism that's written into the statute and our regs, I believe, are with the host communities, with the surrounding communities in mind, because they might be a little later
Right,
to the table.
I think that's right. Okay, enough on that. Did you had something else, Commissioner, from your finance budget update?
Oh, yeah, just one last thing that's still remaining in the agenda. I distributed by email to each one of you the third draft of our employee manual. I have not included it in the packets because I did not expect anybody to read them because we've had a lot to read lately. But I just want to give that brief update that all the comments from the minutes from our August 14 meeting where we discussed the policy decisions around employee manual have now been incorporated in that last draft. They're in revision mode. And if any one of you has any questions in the future, please let me know.
Okay, great. Racing Division.
Two issues I'd like to report to the full commission today. One is an ongoing discussion with the kennel dog owners, lessees, three distinct groups, some of which are the same. And they brought us an issue this summer, once we took, we had responsibility for racing, and that is an issue with regard to payments in the law that were, when Greyhound racing was discontinued, there were some provisions made for those folks who were losing their livelihood. And there was an interpretation made by Department of Professional Licensure, Consumer Affairs about the law, and they did not agree with that. So they brought, I had a group of 11 kennel owners, dog owners in my office talking about this issue. Thank you very much. And they brought it to us informally. We have talked to them about an informal way of looking at this. They were legal issues, so we did engage our outside counsel to take a look informally at this matter. And we have talked about the issue. We thought that one of their claims had some merit, and we have informally advised them of a manner of handling this. And of course, they can come before the full commission if they disagree with our interpretation. I think everyone, when we had this meeting, it was not adversarial. I think everyone agreed that Consumer Affairs interpreted it in a way that they saw, that they thought was the way the law read. Some, as we're all finding out and reading this, there are some things that are not that easy to interpret, could be interpreted more than one way. So those meetings have been ongoing. We did, and to be more specific, one of the issues at hand was the payment of unclaimed wagers, commonly considered outs monies. Those are the unclaimed tickets. And those money, the tickets from, yes.
Right.
From
Winnings.
Correct, correct. And those monies generally went back to this group, traditionally went back to this group, and they made a claim that those monies from '08 and '09 went into the Racing Stabilization Fund rather than to this group. In looking at this matter, it was the recommendation to us, and one that I certainly agree with, that the '08, they had a legitimate claim for '08 monies and not for '09 monies, because the law was already in effect. Because it's a year, you wait a year to make sure someone doesn't claim that money. So we're waiting for a response back from a consensus from this group, whether or not they're satisfied with our interpretation, and they've been told that they can bring this to the full commission if they have an issue with that. So we're trying to listen to everyone that has something to say about this matter.
Is the issue of the unpicked up winnings, whatever you call them, outs?
Outs monies.
Is that the essential issue?
That's one of the issues. The other issue is the composition of the Racing Stabilization Fund. They believe that all racetracks should have been contributing, not just those racetracks that had greyhound racing. So, but the law does not speak to that. They would have to take that matter up with the tracks themselves if they have an issue with regard. We don't have any authority, in other words, to, the law speaks to the monies that come out of the Racing Stabilization Fund. It does not speak to the monies that are put into the fund. So they are very well aware of, we listened to their issues. We had our attorneys take a look for us on behalf of the commission. So this is one of the issues that I've been dealing with, and so we're waiting for a response from those folks back to us, which we should have in the very near future.
Did we give them a written, is there a written summary of our?
We did not.
Okay.
We did not. They came to us informally
Right.
with their concerns. We told them we'd take a look at it informally, but with the understanding they can always come in a more formal manner before the full commission with this matter.
Okay, great.
The second, so that's an ongoing issue, which hopefully we'll have resolved soon. The second issue that I'd like to brief the commission is we have the president and general counsel, Ms. Dorchak, has contacted me personally, and I know she reached out to the chair also. She represents Gray 2K USA, and it's her concern, her opinion that the law in this state, which outlawed greyhound racing, also outlawed simulcast. Now, one of our responsibilities as a commission is to, when I say simulcast of greyhound racing. One of our responsibilities, as we've talked about, is to analyze the simulcast and the parimutuel racing meetings, and to determine the efficiency of the laws and the need to replace pursuant to the continuation of chapters 128A and 128C of the general laws. So we have to have recommendations to the legislature no later than January 1st. We're aware of this deadline, and one of the things we've done is we're contemplating contracting with an attorney who has great subject matter knowledge, and I don't want to mention a name because it's our policy not to mention anyone's name until a complete background investigation is done. So we'll make a recommendation to the full commission when that is complete. And this individual would assist us with, along with the paralegal who has a racing background. So, you know, they're going to take a look at this issue for us. Certainly take into consideration Ms. Dorchak's claim. I mean, I would want the council to speak to her personally and hear her. and make recommendations to us so that we're fully briefed on this issue and we'll be prepared to make those recommendations by January.
So the pari-mutual assessment that we're mandated to do
Correct.
does include,
Simulcasting.
well, and does address the issue, will necessarily address the issue that she's raised about the interpretation of the law.
Correct. We'll be
Okay,
looking
that's
at the
part of it.
simulcasting as it is today.
Right, okay.
Determine if they need to be replaced. So one of the issues we'll be looking at is if her concern is a valid one.
Right, okay.
So we are aware, and we were aware before this conversation about our deadline, and we've taken steps to make sure we meet that deadline by bringing in a consultant to assist us with this matter. So those are the two issues I wanted to
Great.
brief in my racing update today.
Great, that's really interesting. Anything else on racing? Okay, item 7, community and developer outreaches. Should I mention the word Chelsea or move right
Oh,
on?
no, you could mention it and then move right on.
Okay,
I actually took a crack at that. That will be, I guarantee, that will be a featured part of our next meeting.
great, can't wait. We got the opinion from the Ethics Commission, we got that sent to us from Springfield Ethics, the Springfield law firm. Director Driscoll has been talking to us about ways, whether we want to respond, and if so, how. And I think she will be distributing a draft sometime pretty soon. Again, the issue, and we don't have to respond. We're thinking about whether or not we want to say anything further about this issue, or just I think we've taken the position that we're fundamentally accepting of the Ethics Commission decision, but do we want to have any other comment? And we don't know whether we do or not. But because of our time problem, because there's going to be 2 weeks before our next meeting, I'm wondering if you all have your opportunity to give your comments to Director Driscoll, that I could then go ahead and sign a letter that she drafts, if it turns out that you want to. Can we somehow delegate that to, so we can get this out in the next 2 weeks, if you all tell her to do it? Is that,
Yes,
I
I mean,
guess-
technically, we can certainly
We can do that.
We can
Right.
delegate to you the power and authority to
respond.
respond on behalf of the commission to the Ethics Commission opinion if, in your judgment, a response is appropriate.
Okay, if you're comfortable with that, then.
I'm in agreement.
Okay, great, then we'll try to get that done, or not. Okay, acting ombudsman report, that would be me. The list of key contacts for applicants, I think given the late hour, we don't need to pursue this, but I think it's a very good idea, and I forget where all it came from, but a number of suggestions have come up that we recommend to applicants. Once you become an applicant, you not only do you get the opportunity to start working with the state, but also there may be other people who have ideas about community mitigation, about tourism, about whatever, that we would suggest that you talk to. People who we know are
Right.
beginning to reflect ideas and concerns and substantive stuff that are going to be things that we're going to be concerned with in our licensing process. And I think that's a very useful idea. They don't have to talk to people they don't want to, but if we know of resources out there that we think could be constructive working with the applicants once they become applicants, I think that would be a worthwhile exercise. So I think we can pick that up with the ombudsman, but I think it's a nice thought. Community mitigation reimbursements we talked about earlier. I was notified by EOEA, or whatever it's called, Energy and Environmental Affairs, that from the MEPA office, the Mass Environmental Protection Agency office, that Suffolk Downs is filing their environmental notice form or something, ENF,
Environmental notification.
ENF, yeah. So they're moving down the road. But that reminded me of something that I've been thinking about off and on. The MIPA role, environmental, quote, environmental review, is a very important part of the mitigation process. And it seemed to me that it might be useful for us to have the director of MIPA come to one of our meetings and just give us a briefing so we really understand exactly what all goes on there. So if you're in agreement, I'll go ahead and set that up.
That's a
Okay.
great idea.
Okay.
Is it, that ties into the overall permitting process. And there are provisions in the statute that refer to Chapter 40D, I believe it is, 40D as in dog. Is it worth, at the same time, exploring, and that was something that we took up with the secretaries early on. Is it worth revisiting in some fashion that process?
The expedited licensing process?
Yeah, because we're at a point where we're gonna be considering the regulations for the Phase 2 process. And one of the things, just speaking in general terms, that we might want to consider is where are you in the permitting process, and what are your plans and thoughts as to how long the permitting process is going to take, particularly in a competitive environment. One proposal may have greater heft than another, depending on, that may be one factor we want to know about. So it seems to me it might be worthwhile to revisit that issue.
Yeah, I think Commissioner McHugh brought this up when we had our meeting with the governor's chief of staff and all the secretaries, a lot of the secretaries. And you'll be interested in knowing, talking about, is there anything we can do to expedite the permitting process for folks? And there are procedures on the books, and there may be others that we can design, and he's not bringing it up a second time. And I think it's a great idea. I think the ombudsman's the perfect person to lead that, and I've just made a note of that, and I'll make sure that gets picked up right away. I think it's a great idea. We also talked with the governor's office about, we want to establish the Gaming Policy Committee ASAP. We had originally thought that the Gaming Policy Committee, because it had membership of host communities and licensees, was something we wouldn't do until after licensing, but we realized that the law calls on us to use that committee for advice now. So the governor has to appoint the chair and a number of the other positions, so that's underway, and the ombudsman will staff that committee and its subcommittees as well. And after this meeting, I think I circulated a rewrite of the advisory to municipalities that had the schedule on it, and Commissioner McHugh suggested we not post that until we've had this meeting. But I think now that's ready to be edited and reposted, because it's out of date now. The schedule has changed since we published that. So if that's okay, I'll go ahead and fix that. And on the diversity inclusion topic, I think we came away from the educational forum that we had with a sense that there is a lot that can be done here, but it doesn't happen all by itself, and it doesn't happen just by, putting up policy positions on the one hand. And on the other hand, Commissioner Stebbins in particular has been leading the whole workforce development project, not so much the issue of diverse workforce, but just any workforce. So we're maximizing the utilization of Massachusetts residents who are going to be ready to take these jobs when they come. And that too is something that isn't going to happen unless somebody's really focused on it. As well as, finally, Commissioner Stebbins has also been talking a lot about supplier development, teaching small businesses who we will be encouraging the casino operators to utilize how to access their purchasing processes and to get ready for that kind of business and so forth. Not just a diverse supplier base, but a supplier base which is a Massachusetts supplier base, which is really teed up to make the most of this. All of that together is a big responsibility. And I'm wondering, and Commissioner Stebbins and I have talked about this a little bit, and he's got another idea that he may want to speak to that fits into this, but I'm thinking that it's about time for us to write a job description that takes all of those, workforce development and supplier development, with the commitment to make each of those diverse into one job description, at least for starters, and get that person on board pretty soon. I think Commissioner Stebbins has been essentially staffing a number of those efforts, and that's not going to work. But I think if we got a really good, strong person, we could really make a difference in the quality of the local workforce and supplier base that benefit from these expanded gaming facilities. Do you want to add to your?
Yeah, I had taken a crack, and Commissioner Zuniga and I very early on met with Initiative for a Competitive Intercity, Mass Development to ICIC is a national organization. Mass Development is obviously one of the leading quasis here in the Commonwealth that works with businesses of all sizes and provides financing tools and a number of other services. My initial thought around the supplier network, and some thoughts I had were crystallized from our meeting last week on the 19th, is because we don't know where these casinos are going to wind up. Starting with pulling some of these parties together, and Reggie Nunnally from Supplier Diversity Office, and Mr. Marlowe from Access and Opportunity, Mass Development, some of these other, what I would envision are key players, and start thinking about this at a statewide level. Thinking about programs that could build capacity of small businesses, again, to be qualified vendors for a local gaming operator. I tend to shy away from what I could see down the road of some requirement that a gaming operator purchase 50% of their outside spending items from the local community. Well, if the local community doesn't have the capacity, or the businesses don't have the capacity, it's kind of an unfair requirement to place on the casino operators. But if we kind of, as you, Mr. Chairman, pointed out, kind of led them to resources, or at least showed them that there are ways to accomplish their goals and the priorities set out in the legislation, there may be various programs that we can do in connection with, local chambers of commerce, local business groups, et cetera. My initial thought before thinking about a staff person would be to put these people together in a room. Let's think about a good strategic approach. We may find that there may be help or talent within one of those agencies who we can support with commission dollars to kind of help us spearhead the program, and it may be found in one of the service providers. But that would be my recommendation for the first step. We know who some of these players are. It's Mass Development. Associated Industries in Massachusetts has a Buy Massachusetts program. Mass Small Business Development Center, or free counseling help to small business to help them grow and expand their business. So before settling on a staff person, I'd recommend let's have a conversation with that broad group of people, and some of the new names I thought of for that group came out of the Diversity Forum last week, and just say, here's our goal, let's think strategically how to get there. So it may not necessarily be a person we have to hire, but it might be a person who may be within one of these other agencies and may, through a partnership, take the lead with us on that, at least on the supplier vendor piece. On the workforce development front, I know the community colleges have been creating alliances within our 3 gaming regions. As we talked about last week, again at the forum, how do we mentioned the initiative, there was conversation about other wraparound services that need to happen. How do we begin to build people to work within those alliances? And then again, look for capacity of a staff person, either on our behalf or that we might be joint funding with somebody else to kind of manage the program and manage the outreach. I was thinking, maybe this, we've talked about the ombudsman's job kind of morphing in a lot of different directions, but as we've talked today, it sounds like there's going to be a lot on the ombudsman's plate when a candidate comes on board. But I would suggest let's start at that strategic level and then figure out what the staffing need may be. And again, it may be somebody we find within one of our existing partners who we can support and not have to carry the whole financial burden for. But that's just my thought.
Well, I think that's a good idea. I mean, I think that's a good idea. So let's do that. Let's do that soon. This is time sensitive, but it's not urgent time sensitive. So if it takes us a little while to pull this together, it'll have to be after we get back from Vegas probably. So,
Right.
So I agree with that. So I rescind my suggestion, and let's start with that and talk with these folks.
We can start with that, and, obviously, we have a role in this because we're going to be determining licensing credentials for vendors, suppliers, employees. We also have a role because we can be in direct communication with applicants to garner some of this information about workforce, about small business spending that we can share with this kind of, as I would see it, some type of interagency task force to try to address their needs.
I agree and like the idea. I do think, though, that if it's a task force that we're contemplating to make the most of those meetings or sessions, that there is a level of management that or support that has to go with it, which, I know we have some capacity, but we should be conscious of that too.
Yeah.
Yeah.
Well, that's my predisposition too, but I think, but he's not just saying, let's get a task force instead of a person. He's saying that maybe that within the
That's a
task
first.
force, the
Yep.
people are there. I think if these things aren't staffed, they just, are suboptimal. But they could be staffed by some other way than just us going out and hiring a person, and I think that's worth exploring.
Yep.
Okay, so if you'll move on this.
Sure.
That'll be good.
I do think, and I think it's implicit in what we're saying, that we can't lose the energy and focus of, and I know nobody wants to, of that forum. And my prime carry away from that was that unless you have somebody pretty high up in the organization, it's not going to work. So that at some point, as we filter our way through that and build out our organization chart, we ought to have a placeholder in at least our thinking to figure out what we do to ensure that we can be effective in that space.
Right. I mean, I think you're hearing from three of us that we all have a predisposition that having a high-level person who's going to be pushing these agendas is really important. Having said that, I still think your idea is a good one.
No, I
yeah.
fully agree with
Right.
the way, but and how.
But I think
and
we all have the
person-
same instinct
yeah,
here.
This person who we're thinking about may have more than one function. I mean, there's other,
Right.
but we just need to think about this space.
Right.
Which I know we are.
But to pick up on your point, I don't think the statute necessarily limits us in terms of, we know we need a gaming policy advisory committee and some related committees under that, but
Right.
we may be just taking it upon ourselves to build structures for similar topics kind of underneath that.
Right.
Nothing that says we can't.
Absolutely. No, absolutely. Right. But just to finish that thought, we're hiring an ombudsman to staff the gaming advisory committee to
Right,
make sure
right.
that that's really a meaningful body.
Right.
But I think we're agreeing here. Okay, research we talked about, Commissioner Glovsky talked about the RFI is out. We will, by the time we get back from Las Vegas, we'll be in pretty good shape. Commissioners Cameron, Zuniga, and Crosby will be going to Las Vegas first for the National Responsible Gambling Conference of a day and a half starting on Sunday, and then 3 days for the American Gaming Association Conference. And Commissioners Stebbins and McHugh will be here holding the fort.
No, taking over.
taking over. Right. Any other items or anything that anybody wants to speak to?
We covered it all.
All right, all in favor? Aye.
Aye.
Meeting adjourned. Thank you all.